The sixth important source of Hindu law is equity, justice, and good conscience. So, equity as a branch of legal system may be said to mean the principles or rules emerging in the course of administration of justice, particularly in those cases where on account of inadequacy of law, the judges evolve certain general principles on the basis of justness, fairness, and propriety. And Kautilya has said that if Dharma's text is found opposed to judicial reasoning, the Dharma text fails and the authority of reason prevails. According to Yagnamlaka, if there is a conflict between two Smritis, equity should supersede law. The rule is that a religious code, Dharma Shastra, is superior to a secular code, and that is Artha Shastra. So, regarding that, we will discuss a leading case that was Tagore versus Tagore, and it was a case of 1872 and it was decided by the Privy Council. So, the Privy Council involved the very principles of justice, equity, good conscience from the law of gift and applied them to the law of wills and pointed out in the same case that it is the duty of a court dealing with a case new in instance to be governed by the established principles and the analogies which have therefore prevailed in like cases. In the same way, our Supreme Court in 1951 in Gurunath versus Kamlabai, the Supreme Court has recognized equity, justice, and good conscience as a source of Hindu law. It has observed that it is now well established that in the absence of any rule of Hindu law, the courts have authority to decide cases on the principles of equity, justice, and good conscience, unless in doing so, decision would be repugnant to or inconsistent with any doctrine or theory of Hindu law. So, this is how equity, justice, and good conscience played an important role as a modern source of Hindu law as it was applied by the Privy Council in Tagore versus Tagore in 1872. So also our Supreme Court in the leading case Gurunath versus Kamlabai in 1951.